This is the day after the ruling that has got many Nigerians talking, and that's the Code of Conduct Tribunal's acquittal of Senate President Bukola Saraki on an 18-count charge of false assets declaration and money laundering. TVC News' Sifon Essien was at that ruling.
The premises of the Code of Conduct Tribunal was devoid of the razzmatazz typical of the trial of the Senate President. More so, just a handful of his supporters were on hand. Then came the decision of the Code of Conduct Tribunal, read by its chairman, Justice Danladi Umar. He ruled that in spite of fielding 4 witnesses, the prosecution could not prove its case against the former governor of Kwara State. Justice Umar held that the witness testimonies were inconsistent. More so, the prosecution failed to link Saraki with the offences despite the 48 exhibits it tendered. The tribunal, for want of sufficient evidence, discharged and acquitted Senator Saraki. The Senate President's supporters went into a frenzy.
No, let me put my own. It's too long.
We've never felt that justice was not possible. Those complaints were based on the events of the time. But we are happy that the verdict has vindicated the position of the Senate President. If we had really felt that we could not get justice here, we would have proceeded to the Supreme Court when our application for the chairman to recuse himself was refused. But we were confident that our protests and all of that would make an impact, and that in the end justice would be done.
It's not an end. We have not come to the end. This is a ruling, and we have already started making arrangements to get a copy of the ruling. We study it, and then we know the next line of action, what next to do.
The prosecution had on 5 occasions brought new counts against the Senate President, and the charges had risen from 13 to 18, yet it was unable to prove its case. For now, the Senate President can heave a sigh of relief. Sifon Essien, TVC News, Abuja.
Unexpectedly, an elated Senator Saraki reacted immediately after the ruling, saying the outcome has vindicated him. The Senate President, in a couple of tweets, said the ruling has further renewed his faith and restored his hope in the nation's judiciary. According to him, quote, "The conclusion of this trial has vindicated my position. With the outcome of this case, our faith is renewed in our courts, and our hope is restored that the judiciary in our country could indeed provide sanctuary for all those who seek justice." End quote. Well, Professor Itsi Sage, who chairs the Presidential Advisory Committee Against Corruption, has expressed his shock over Saraki's acquittal. According to him, the government presented enough evidence to secure a conviction. The way forward now, he says, is for government to appeal the ruling. And let's talk more about this as we talk to constitutional lawyer Kennedy Osunwa. First off, thank you for your time for joining us on the news. Are you happy with the ruling?
Good morning. Thank you. Good morning. Yes. I think what has happened has proved that the Senate President is innocent, because the presumption of innocence, as provided in Section 36(5) of 1999 Constitution as amended, has worked in his favor. You see, the alleged breach of the Code of Conduct Bureau in pursuant to paragraph 11, part 1 of the 5th schedule to 1999 Constitution, that provides for every public officer to give a declaration of his assets, his liabilities and properties, and that of his spouse, if not a public officer, and that of his children above 18 years, to be handed to the Code of Conduct Bureau. However, sometime in 2016, the Senate President issue started. And of course, the principle of law is that he who alleges must discharge the burden of proof. And from what has happened, both in the evidence of the prosecution, even during the cross-examination, the defense has discredited the evidence against the Senate President. And by around the 4th of May, the president of the Senate Council filed a no-case submission, and in the ruling of the learned judge of the CCB, he has dismissed in its entirety the case of the president of the Senate, and that goes to show, like I said, that the presumption of innocence is in favor of the Senate President.
All right.
Now the Senate President and the entire legislature can now sit down and do the work that the Nigerians elected them to do.
All right, but many legal practitioners in the country are saying that there were enough evidences to convict the Senate President, that they are seeing this as daylight robbery when it comes to the fight against corruption of the present administration.
Well, my position is this: it is not enough for us as legal practitioners or officers of the court to be outside the courtroom to say that there's overwhelming evidence. Yes, there is evidence, but that evidence must go through the fire of cross-examination. If at the fire of cross-examination the defense is able to discredit the evidence of the prosecution, then in its entirety, the case of the prosecution must fail. And as you can see, that is what has come to play. And if you look at what played out right from the inception of this matter, you will understand and agree with me that even Justice Omar, that presided over this case, with the other judge, you will see that they have been thorough in their work. And also, the prosecution has equally not given chances, even from this inception. But however, the main gamut of the trial is the fire of cross-examination. And the essence of the cross-examination is to debunk and to discredit the evidence of the prosecution. And following the ruling of the court that dismissed this case, you will agree with me that the prosecution has not done enough. And that is why I say it is not enough for people to come to court. It is not enough for people to arraign alleged accused persons. But what matters is how thorough have you investigated your matter. Because the investigation gives birth to the drafting of the charge, and the drafting of the charge gives birth to what the judgment will be like.
And yet the burden of proof again is
where the burden
let me come in here and quickly ask you because of time.
The burden of proof has to be discharged.
All right, yet again, just like the EFCC is facing, having the responsibility to prove beyond reasonable doubt that a defendant is guilty in any case, is falling again and has played out in this case. But Nigerians are saying that if popular people that are seen as corrupt are not prosecuted, why then is the common man taking the boot every time?
I want you to understand one thing. The opinion of a layman does not form the principle of law. And the gamut of trial is also the outcome of what has been done during investigation and the charge, and then the discharge of the burden of proof. And all the totality of all this is in the hands of the prosecution. So it all depends when we look at, when we have the judgment and the ruling and look at it critically. It all depends on the case of the prosecution. It all depends on how well the prosecution has been able to discharge the burden of proof that is on them. It is only when that burden of proof is discharged effectively that the case of the Senate president will see the light of the day. But wherein the burden of proof is not discharged effectively, I don't think that case will see the light of the day. And that is the reason why, in my own opinion, I think the judge dismissed the case.
And of course, every suspect is adjudged innocent until proven guilty in the court of law. Thank you for your analysis, constitutional lawyer Kennedy Osunwa.